Chapter 4. The Master's Relation to the Crew. Shipment, Shipping Papers, Discharge, Imprisonment, Punishment. Shipment. The master of every vessel of the United States, bound on a foreign voyage, and of all coasting vessels of 50 tons burden, must make a contract in writing, shipping articles, with each seaman, specifying the voyage, terms of time, etc., and in default thereof shall forfeit $20 for every case of omission, and shall be obliged to pay every such seaman the highest rate of wages that have been paid for such voyages at the port of shipment within 3 months previous to the commencement of the voyage. Act 1790, Chapter 56, Section 1. And when the master ships a seaman in a foreign port, he must take the list of crew and the duplicate of the shipping articles to the consul or commercial agent, who shall make the proper entries thereupon. And then the bond originally given for the return of the men shall embrace each person so shipped. All shipments made contrary to this or any other act of Congress shall be void, and the seaman may leave at any time, and claim the highest rate of wages paid for any man who shipped for the voyage, or the sum agreed to be given him at his shipment. Act 1840, Chapter 23, Section 1. At the foot of every such contract there shall be a memorandum in writing of the day and hour on which such seaman shall render himself on board. If this memorandum is made and the seaman neglects to render himself on board at the time specified, he shall forfeit 1 day's pay for every hour he is so absent, provided the master or mate shall, on the same day, have made an entry of the name of such seaman in the logbook, specifying the time he was so absent. And if the seaman shall wholly neglect to render himself on board, or, after rendering, shall desert before sailing, so that the vessel goes to sea without him, he then forfeits the amount of his advance and a further sum equal thereto, both of which may be recovered from himself or his surety. Act 1790, Chapter 56, Section 2. There is no obligation upon the master to make these memorandums and entries, other than that the forfeitures cannot be inflicted upon the seaman, unless they have been made literally, according to the form of the statute. If any seaman who has signed the articles shall desert during the voyage, the master may have him arrested and committed to jail until the vessel is ready to proceed, by applying to a justice of the peace, and proving the contract, and the breach thereof by the seaman. Act 1790, Chapter 56, Section 7. Every vessel bound on a foreign voyage shall have on board a duplicate list of the crew, and a true copy of the shipping articles, certified by the collector of the port, containing the names of the crew, which shall be written in a uniform hand, without erasures or interlineations. This copy the master must produce to any consul or commercial agent of the United States who shall require it, and it shall be deemed to contain all the conditions of the contract. All erasures and interlineations shall be deemed fraudulent, unless proved to be innocent and bona fide. Every master who shall go upon a foreign voyage without these documents, or shall refuse to produce them when required, shall forfeit $100 for each offense, besides being liable in damages to any seaman who may have been injured thereby. Act 1840, Chapter 23, Section 1. Shipment in England. By the Act 5 and 6 William IV, Chapter 19, the master of every ship belonging to an English subject, trading to parts beyond the seas, or of any British registered ship of the burden of 80 tons, employed in any of the fisheries of the United Kingdom, or in trading coastwise or otherwise, must make a similar contract in writing, shipping articles, with each seaman, apprentices excepted, and in default thereof shall forfeit £10 2 shillings. If after entering into such agreement a mariner neglect or refuse to join the ship, or to proceed to sea in her, or absent himself without leave, any justice of the peace, upon complaint of the fact made upon oath by the master, mate, or owner of the ship, is required by his warrant to cause the seaman to be apprehended and brought before him. And in case he shall not give a reason to the satisfaction of such justice for his neglect, refusal, or absence, as the case may be, such justice may commit him to the house of correction, there to be kept to hard labor for a period not exceeding 30 days. But if the seaman consent to join the ship, the justice, at the request of the master, instead of committing the seaman, may order him to be conveyed on board the ship, or delivered to the master for the purpose of proceeding upon the voyage, and may award to the master costs not exceeding 40 shillings, to be abated from the wages of such seaman. Section 10. As regards temporary absence, if such seaman shall wilfully and without leave absent himself from the ship or otherwise from his duty, he shall, in all cases not of absolute desertion or not treated as such by the master, forfeit out of his wages to the master or owner 2 days' pay for every 24 hours of such absence, and in a like proportion for any less period of time, or at the option of the master, the amount of such expenses as shall have been necessarily incurred in hiring a substitute to perform his work. Section 7. In cases of absolute desertion, such seaman shall forfeit to the owner or master all his clothes and effects on board, and all wages and emoluments, and in case of desertion aboard, shall be liable to the increased wages which may be paid to a substitute. Section 9. The forfeitures are not incurred unless due entries shall be made in the logbook, as required by the Act. The entry into the naval service of Her Majesty by any seaman in the merchant service shall not be deemed a desertion, or incur any penalty or forfeiture of wages, clothes, or effects. Section 45. The master is required to deliver the shipping articles to the consul or vice-consul on arrival at a foreign port, under the penalty of £25. Section 48. Discharge. If the master discharges any seaman in a foreign port, with his own consent, he shall pay to the consul 3 months' wages for every such seaman, in addition to the wages then due to him, 2/3 to go to the seaman upon his taking passage for the United States, and the remainder to be retained by the consul to make a fund for the relief of destitute seamen. Act 1803, Chapter 62, Section 3. See also Act 1840, Chapter 23, Section 5. The master of every vessel bound to the United States shall, upon the request of the consul, take on board any seaman, and transport him to the United States, on terms not exceeding $10 for each seaman, under penalty of $100 for every refusal. He is not, however, bound to receive more than 2 men to every 100 tons. Act 1803, Chapter 62, Section. The whole policy of the United States discourages the discharge of seamen in foreign ports. If the seaman is discharged against his consent and without justifiable cause, he can recover his wages up to the time of the vessel's return, together with his own expenses. The certificate of the consul will not of itself prove the sufficiency of the cause of discharge. Though the seaman shall have made himself liable to be discharged, yet if he repents and offers to return to duty, the master must receive him, unless he can show a sufficient cause of refusal. Ware 65. 4 Mason 541, 84. If the master alleges as a cause for discharging a seaman that he was a dangerous... It must be shown that the danger was such as would affect a man of ordinary firmness. Ware 9. In addition to the master's liability to the seaman, he is criminally liable to the government for discharging a mariner without cause. The statute enacts that if the master shall, when aboard, force on shore or leave behind any officer or seaman without justifiable cause, he shall be fined not exceeding $500, or imprisoned not exceeding 6 months, according to the aggravation of the offense. Act 1825, Chapter 276, Section 10. Notwithstanding these liabilities, the master may discharge a seaman for gross misconduct, yet the right is very strictly construed. Abbott on Shipping, 147, note. Discharge in England. Whenever any ship belonging to an English subject, except in cases of wreck or condemnation, shall be sold at any port out of Her Majesty's dominions, the master, unless the crew in the presence of the British Council or Vice-Council, or in case of there not being any such council or vice-council, then in the presence of one or more British resident merchants at such port, shall signify their consent in writing to be there discharged, is required, besides paying them their wages under the agreement, either to provide them with adequate employment on board some other British vessel homeward bound, or to furnish the means of sending them back to the port in Her Majesty's dominions at which they were originally shipped, or to some port of the United Kingdom, as shall be agreed upon, by providing them with a passage home, or depositing with the Council or Vice-Council such a sum of money as shall be by him deemed reasonably sufficient to defray the expenses of their subsistence passage. 5 and 6. William IV, Chapter 19, Section 17. And if the master of such ship shall force on shore and leave behind, or shall otherwise wilfully and wrongfully leave behind on shore or at sea, in any place in or out of Her Majesty's dominions, any person belonging to his crew before the return to or arrival of such ship in the United Kingdom, or before the completion of the voyage or voyages for which such person shall have been engaged, whether such person shall have formed part of the original crew or not, every person so offending shall be deemed guilty of a misdemeanor, and shall suffer such punishment by fine or imprisonment, or both, as to the court, at home or abroad, before which he shall be convicted, shall seem meet. Section 40. And the master shall not discharge any of his crew, whether foreigner or British subject, at any of Her Majesty's colonies or plantations, without the sanction in writing of the governor, secretary, or other officer appointed in that behalf, or in the absence of such authorities near the place where the ship is lying, then of the chief officer of customs, resident at or near such place, nor at any other place abroad, without the sanction of Her Majesty's minister, council, or vice-council, or, in their absence, of 2 respectable merchants resident there, all which functionaries and merchants are empowered to inquire in a summary way into the grounds of such proposed discharge, by examination on oath, and to grant or refuse such sanction according to their discretion. Section 41. And no master shall leave behind at any place abroad any person of his crew on the plea of such person not being in a condition to proceed on the voyage, or having deserted from the ship, unless upon a previous certificate in writing from such functionaries or merchants, if there be any such within reasonable distance, and there be time to procure the same, certifying that the person so intended to be left is not in such condition, or has deserted and disappeared, and cannot be brought back. And such functionaries are authorized, on the application of any such master, to inquire by examination on oath into the circumstances, and give or refuse such certificate according to the result of such examinations. Section 42. The master of every ship bound to Great Britain is bound, at the request of the Council, to receive on board seamen not exceeding 4 persons for every 100 tons of his ship's burthen, and to transport them to Great Britain, on being paid by the commissioners of the navy for such of them as he may not want, toward his own complement of men, according to such rate per day as shall be authorized by the commissioners for executing the office of Lord High Admiral. (11) George IV and 1 William IV, Chapter 20, Section 82. Imprisonment. The master has the right to imprison a seaman in a foreign port, in a case of urgent necessity, but the power has always been very closely watched by courts of law. The practice of imprisoning seamen in foreign jails is one of doubtful legality, and is to be justified only by a strong case of necessity. Gilpin 31, Ware 19. The master is not authorized to punish a seaman by imprisonment in a foreign jail, unless in cases of aggravated misconduct and insubordination. where 503. If he does so punish him, he is not permitted to deduct his wages during the time of imprisonment, nor charge him with the expense of it, where 9, 503. If the imprisonment is without justifiable cause, the master is not excused by showing that it was ordered by the council, where 367. And generally, the advice of a council is no justification of an illegal act. Gilpin 31. Punishment. The master may inflict moderate correction on a seaman for sufficient cause, but he must take care that it is not disproportionate to the offense. If he exceeds the bounds of moderation, he is treated as a trespasser, and is liable in damages. 1 Peters ad 186, 172. 2 Peters ad 420. 1 Washington 316. In respect to the mode of correction, it may be by personal chastisement, or by confinement on board ship, in irons, or otherwise. 1 Peters ad 186, 168, 15 Mass 365. But there must not be any cruelty or unnecessary severity exercised. The mode, instruments, or extent of the punishment are not laid down by law. These must depend upon circumstances. In case of urgent necessity, as of mutiny, weapons may be used which would be unlawful at other times. But even in these cases, they must be used with the caution which the law requires in other cases of self-defense and vindication of rightful authority. Same cases. It is not necessary that the punishment should be inflicted to suppress the offense at the time of its commission. It may be inflicted for past offenses, and to promote good discipline on board, but the reference to bygone acts should be very clear and distinct, or they will be presumed to have been forgiven. 1 Hag 271. In many cases prudence may require a postponement of the proper punishment. The authority of the master, being in its nature parental, must be exercised with a due regard to the rights and interests of all parties. He has a large discretion, but is held to answer strictly for every abuse of it. 15 Mass 365, 3 Day 294. The law enjoins upon him a temperate demeanor and a decent conduct towards seamen. He risks the consequences if he commences a dispute with illegal conduct and improper behavior. 4 Wash 340. In all his acts of correction he must punish purely for reformation and discipline, and never to gratify personal feelings. 1 Pet ad 168, 173, note. If a master generally permits or encourages disorderly behavior in his ship, he is less excusable for inflicting unusual punishment on account of misconduct arising out of that disorder. B. 239. If the case admits of delay and the master does not make proper inquiry before punishing, he takes the consequences upon himself. 1 Hag 271. This power over the liberty and person of a fellow man, being against common right, and entrusted to the master only from public policy, regarding the necessities of the service, is to be sparingly used, and a strict account will be required of its exercise. The master is responsible for any punishment inflicted on board the vessel, unless in his absence, or when he is prevented by force from interfering. 2 Sumner 1, where 219. Neither will absence always be an excuse. If he had reason to suppose that such a thing might be done, and did not take pains to be present and interfere, he will be liable. Neither, as is often supposed, will the advice, or even the personal superintendence or orders of a council, or any foreign authority, relieve the master of his personal responsibility. Where 367, Gilpin 31. He may ask advice, but he must act upon his own account, and is equally answerable for what he does himself, and what he permits to be done on board his vessel by others. The seaman is entitled to be dealt with by his own captain, under whom he shipped, and whom he may hold responsible at the end of the voyage, and this responsibility is not to be shaken off by calling in the aid of others. In case of an open mutiny, or of imminent danger to life and property, the master may make use of the local authorities. But then he is to remember that he can use them no further than for the purpose of quelling the mutiny, or of apprehending the felon. As soon as his authority is restored, the parental character is again thrown upon him, and all acts of punishment must be upon his own responsibility. He has no right to punish criminally. He has no judicial power. If a seaman has committed an offense further than against the internal order and economy of the ship, and which moderate correction is not sufficient to meet, the master must bring him home, in confinement if necessary, or send him immediately by some other vessel, to be tried by the laws and by a jury of his country. 1 Peter ad 168. The practice of subjecting American seamen to foreign authority, or to persons whom they cannot well hold answerable, like that of foreign imprisonment, is an odious one, and must be justified by an overpowering necessity. A recent statute, Act 1840, Chapter 23, Section 1, makes it the duty of councils to exert themselves to reclaim deserters and discountenance insubordination, and authorizes them to employ the local authorities, where it can usefully be done, for those purposes. But this will unquestionably be restricted to the apprehension of the deserter, and the quelling of the revolt or mutiny, and as soon as these ends are attained, the sole responsibility of the master in dealing with the crew will reattach. If the master is present while the mate or any subordinate officer inflicts punishment upon any of the crew, or if it is inflicted under such circumstances as would raise a presumption that the master was knowing of it, and he does not interfere, he will be held to have adopted it as his own act, and will be answerable accordingly. 2 Sumner 1. In addition to the master's liability to the seaman in damages for abuse of power, he is also liable, as a criminal, to fine and imprisonment. A recent statute enacts that if any master or other officer of an American vessel shall, from malice, hatred, or revenge, and without justifiable cause, beat, wound, or imprison any one or more of the crew of such vessel, or withhold from them suitable food or nourishment, or inflict on them any cruel or unusual punishment, every such person so offending shall, on conviction thereof, be punished by fine not exceeding $1,000, or by imprisonment not exceeding 5 years, or by both, according to the nature and aggravation of the offense. Act 1835, Chapter 313, Section 3. It is held that the word crew in this statute includes officers, and accordingly a master was punished for unjustifiably confining and otherwise maltreating his chief mate. 3 Sumner 209. To constitute malice in the above statute, it is not necessary to show malignity as it is commonly understood, or brutality, but the term in law requires no more than a willful intention to do a wrongful act. An offense is punishable under this act, even although no bad passions came into play, as hatred or revenge, for the term malice in law covers all cases of intentional wrong, in their mildest form. 2 Sumner 584. If a seaman desires to lay any complaint before a council in a foreign port, the master must permit him to land for that purpose, or else inform the council immediately of the fact, stating his reasons in writing for not allowing the man to land. If he refuses to do this, he forfeits $100 and is liable to the seaman in damages. Act 1840, Chapter 23, Section 1. Imprisonment and punishment in England. By the law of England, the master of a ship has a right to correct and punish a disorderly or delinquent mariner in a reasonable manner. This punishment may be by the actual infliction of corporal punishment, if absolutely necessary. But before the master proceeds to punish in this manner, he should take the advice of the persons next below him in authority, as well to prevent the operation of passion in his own breast, as to secure witnesses to the propriety of his conduct. The master may be called upon by action at law to answer to a mariner, who has been beaten or imprisoned by him or by his order in the course of a voyage. And for the justification of his conduct, he should be able to show not only that there was a sufficient cause for chastisement, but also that the chastisement itself was reasonable and moderate. Otherwise, the mariner may recover damages proportionate to the injury received. Abbott on Shipping, 6th edition, 156. 2 Boss and Pull, 224. See also on this subject 1 Hag, 161, 271, 384, 395, 6 C&P, 471. 5 and 6 William IV, Chapter 19, Section 38.